Dave, I saw you come out of the courthouse. I said, how was it? You said excited. Tell us how it all went.
It was great. Alan Gura did a fabulous job in the oral argument. I went in thinking that we were ahead on the briefs, and it was sort of like a debate where last debate before the election, and one candidate's got an 8% lead in the polls, so all he has to do is not lose that debate by too much, and it went way better than that. Alan did a super job. You know, Walter Delinger, the lawyer for D.C., did a very good job too. He's an experienced Supreme Court lawyer and did as well as he could with the weak facts and law that were on his side. But Alan Gura was magnificent, and I don't want to make a prediction, but I'm feeling very comfortable about the result in the case.
Well, talking to everybody out here in the crowd, they all seem to have the same reaction. When you were in there and you were sitting at the table, the justices' questions, anything really stand out in your mind?
You could clearly see Justice Kennedy, for example, who's concerned in lots of contexts with people's freedom in a practical sense. And his questions seemed to indicate that he was very interested in that, in the right to self-defense. I think you can see from a lot of the justices, I think they understand that United States versus Miller might have been a reasonable decision at its time, but that this framework it has needs to be updated and changed and brought into the 21st century, where they're going to say the Second Amendment includes your right to have a handgun. It does not include a machine gun.
Justice Scalia, Justice Roberts, questions I heard really good, but also some of the people we interviewed said that they were kind of candid too about how long does it take to get your gun if you need your firearm.
They were very much concerned about the practicalities of it, and I think it's important that this case doesn't challenge trigger lock laws in general. All it does is challenge a trigger lock law that is meant to be, as the district has defended it in the federal district court in this case, and in McIntosh versus Washington in the D.C. Court of Appeals in 1977, that law was meant to prohibit home defense. If you have a trigger lock law that has a reasonable exception for when people need to protect themselves, that's going to be fine with this court. But a trigger lock law that is really just a self-defense ban in disguise is not going to be upheld.
And I know that the district was going to, as I understood it, talk a lot about how this was a reasonable restriction because you were allowed to still own a shotgun and a rifle, but we all know it has to be disassembled. Did that come up?
It did, and Chief Justice Roberts asked the question and said when Walter Delinger was saying it's okay because we can still have rifles and shotguns, he said, isn't that like in a First Amendment context? If you say we can ban books, but you can still have newspapers and magazines, and that's exactly the analogy that our side has been making. So it was nice to see that the Chief Justice sees it that way.
Justice Ginsburg, any questions she asked that stand out?
Pretty intelligent ones, but I think ones that seem consistent with my hope that she's going to be on the right side of this case.
Now, I know you were at the table, and you were telling me earlier you were there in case that, real constitutional questions came up. Did you have to scribble any notes to Alan or get any information to him?
I got a little bit to him, but he was very, very, very well prepared. He knew, exactly what he needed to. There was hardly anything that the justices asked him that he didn't have a ready answer for. One of the things that I gave him was on 19th century state court interpretations of some of the founding era state constitutions, and he started trying to go down that road, and Justice Stevens didn't want to hear it. Basically Justice Stevens was saying, well, these constitutions such as in Virginia or like the North Carolina Constitution or Massachusetts only talk about the common defense, and Alan was trying to explain that's true, but their judicial interpretations are much broader than solely for the common defense. But Justice Stevens, I think, knew what the answer was going to be and didn't want to let Alan give too much of an answer on that one.
No doubt. Go ahead.
I think all the justices were very well prepared. This is a bench of 9 really intelligent, conscientious, hardworking jurists, and I think all of their questions, from whatever perspective, were extremely intelligent and showed they'd done a lot of work on the case.
And no doubt, a landmark decision coming in June, and again, implications that are nationwide, aren't they?
Well, eventually, but remember that the Second Amendment, like the rest of the Bill of Rights, originally limited only the federal government, and Washington, D.C. is an extension of the federal government. This case, I think, is unlikely to decide whether the Second Amendment's enforceable against state or local governments. That'll be decided another day, and hopefully in a case where good lawyers like Alan Gura or others, or Steve Holbrook, can challenge the handgun prohibition in Chicago and in some of the Chicago suburbs, or other really unreasonable anti-self-defense applications of gun laws in other jurisdictions. But it's really important that the NRA listeners and everybody else out there understand this is about an extremist prohibition law, and it would be a grave mistake for people to think that, let's say we win this case in a decision that's announced in mid-June, that's not going to wipe out gun control across the country. It's going to leave 99% plus, at least, of other state, local, and federal gun controls in place. The protection of the Second Amendment is going to remain starting July 1st, 2008, even with the best possible win in this case, is going to remain very heavily dependent on citizen activists, on groups like the National Rifle Association, on people being involved in elections and in writing letters to the editor, and all the other things that have brought us to this day, that have set the background for making this Supreme Court possible victory something that could become a reality. But it's never going to be a case where the Supreme Court or any other court is just going to wipe out gun controls in general. If you don't want to register your guns, if you think a licensing law might be unreasonable for having a gun in your home, that is going to be left by the courts to the political process, to legislatures, and will not be wiped out by the courts.
What I hear you saying is really what we're looking at here is constitutional history in doing something that hasn't been done, and that's defining the right as an individual right.
Right, affirming what has really been the traditional understanding expressed in lots of Supreme Court cases. You know, in my article, the Supreme Court's 35 other Second Amendment cases, they have generally recognized the Second Amendment as an individual right, although often doing so in passing in another context. But I am hopeful that this case will be the definitive end of that fraud that was invented in the 20th century by the gun prohibition lobby and other extremists, that the Second Amendment guarantees no meaningful right at all. It's a right that's going to be subject to lots of regulations and legislative restrictions, but it's going to be treated as a meaningful right.
As you said, you can never read what the court's going to do, but I can tell from a lot of people's faces out here, a lot of smiles, that you're feeling pretty good.
We are very hopeful, and the reason we're hopeful is not just because the lawyers in this case did a great job, which they certainly did, but because of what's been going on for the last 30 years with groups like the NRA and a whole coalition of citizen activists doing things to educate the country about the Second Amendment, and, very importantly, to elect presidents who would appoint the kind of justices on the whole who are likely to rule pro-Second Amendment, which is not to rule out Justice Breyer or Justice Ginsburg as hopefully ruling in favor of the Second Amendment as well. But clearly, everything that's been going on for by pro-Second Amendment activists over the decades is the background to this possible victory.
And you bring up an interesting point before I let you go. An election year, and you see this decision coming out in June. It could have a big impact, could it not, as far as what's discussed as we go down and into the final months of the campaigns?
Sure. Senator Obama has said that he taught constitutional law at the University of Chicago, that he thinks the Second Amendment is a real individual right, but he also thinks that D.C.'s complete ban on handguns is reasonable and should be upheld. That's a philosophically defensible position, although I think it's one that goes along with a lot of other extremist gun control proposals he's advocated in the past. And the voters will have an opportunity to decide if they want a president who recognizes the right but wants it constricted to such an extreme degree.
And the importance, too, that whoever's in that White House appoints those justices, and that makes a big difference.
Absolutely, and based on the arguments we've heard, I'd say we've had a lot of good judicial appointments recently. And again, I'm not ruling out Justice Breyer and Justice Ginsburg as vindicating the Second Amendment themselves.
All righty. As always, great talking to you.
It's great. Thanks.
Thanks.